Welcome to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate an engaged, stable, and inclusive workforce. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every employer's mind: how will my business be impacted? Employers in the technology industry are preparing for monumental changes in immigration enforcement under the new presidential administration, from increased ICE site visits to I-9 audits. On this episode of We Get Work, we speak with Jaimie Cremeans, Director of Immigration Counsel at RingCentral. Jaimie shares what she and other technology employers should consider and how they can work collaboratively with other company stakeholders to best safeguard their business. Our co-host today is Kimberly Bennett, associate in Jackson Lewis's Pittsburgh office and a member of the immigration and technology groups. Kim and Jaimie, the question on everyone's mind today is, what can technology employers do to stay ahead of and best prepare for potential enforcement efforts? And how does that impact my business?
Thanks so much, Alicia, and thank you so much for joining, Jaimie. I'm looking forward to speaking with you today. So let's just go ahead and get right into it.
Sure.
As the Director of Immigration for a technology company, what are some of the things that you're worried about today in immigration?
A few things. So I think a lot of it at this point is primarily speculative, because there hasn't been a ton of action directly affecting employment-based visas at this point. But the main things I'm concerned about, first of all, enhanced visa vetting obviously is going to be potentially causing some delays in visas. Anyone who works on employment-based visas, particularly in the tech industry, would know that we want to move quickly, right? So if we're filing a visa for somebody, we want them to get approved right away. I think this enhanced visa vetting could potentially cause delays in getting people over here. The other piece I'm concerned about is just stricter interpretation of the qualifications, like what happened, in the last Trump administration, as far as H-1Bs, Ls, other employment-based visas just being kind of enhanced scrutiny, taking the strictest interpretation of the law to try to, increase denials, RFEs, things like that. The last few things, obviously with all of these recent cuts in the government, I'm a little bit concerned about USCIS and DOL delays in processing perm cases and other filings. What's going to happen if we start cutting employees in those departments, which, already are a little bit slow, particularly the DOL processing times right now. And then, just generally enforcement. I think enforcement is going to be a bigger, piece of the Trump administration this time around. DOL audits, I-9 audits, getting into our perm files and our public access files. So those are the main things that I'm particularly concerned about and preparing for on our end.
Yeah, all valid concerns. I feel the same way. Well, let's start with the executive orders. Let's start with what has already happened, what we maybe see coming down the pike, even if there hasn't been an executive order issued yet. You mentioned enhanced visa vetting. So let's talk about exactly what do we mean when we say enhanced visa vetting. I mean, it's sort of in the name itself, but we're looking at increased scrutiny on either visa applications at U.S. embassies and U.S. consulates, or advanced scrutiny or increased scrutiny on petitions filed with the USCIS. What are some specifically some of the things that we might see or that you have concerns about?
I think for me, particularly because the executive order specifically says enhanced visa vetting and seems to be more aimed at security, worried about people coming from different countries and, particularly targeting extra security vetting. My biggest concern is consulates and consular processing of visas. I think that that's where we're going to see probably the most, significant delays. We're already seeing these, frankly, in some of our cases. So I have a case right now that's been in administrative processing for, I want to say, like 8 months. So it's already pretty long if they get stuck in administrative processing. My concern is just what happens if, obviously that increases. In that one particular case that we have, I'm constantly being, asked to follow up, see what we can do. And frankly, there's just not much you can do if they're stuck in security processing. So I think that for me is the biggest concern. Obviously, USCIS increased vetting is another concern of mine, but I'm more concerned with the parts that you have less control over, in my opinion.
Yeah, we both know very well that if you get stuck in administrative processing, it really is a black box, and there's really not much you can do. Yeah, those are not fun. Actually, you mentioned you're already seeing this at the embassies and consulates. We are as well, and just wanted to mention that Department of State did resurrect an old outreach email, client verification at state.gov, and that email so far we've seen is being used to confirm that contractors that are placed at third-party work sites are in fact being placed at those third-party work sites. So we've actually had a client that received one of those emails for someone who is not one of their employees, but they have hired a contractor, and this person will be actually placed at their work site. And so they did receive an email verifying that. So I think particularly for technology companies that are using a lot of contract work, where they have people being placed at their work sites as the end client, I do think that we're going to see increased scrutiny of that using that old outreach email.
Mm-hmm.
Yeah.
And we thankfully do not do that much. So I'm not super concerned about that, but I do understand why that would be a concern for obviously a lot of tech companies. That's a very common model in the industry.
Yeah, definitely. Another thing to maybe talk about is, what are some other executive orders that we're seeing, not necessarily related to enhanced visa vetting? What else are you worried about?
So just a couple of them, because again, I think a lot of the executive orders so far are not particularly targeting employment-based things that directly affect us, but there are some things that potentially could lead to, just limiting overall visa categories and options for people. So getting to, the America First Trade Policy executive order, again, we don't know exactly what that's going to look like when it all shapes up, but there's the possibility that they could restrict TN visas, which obviously would cause concern if you're pulling talent from Canada or Mexico. Again, we have some of these, so that would be something that I'd be concerned about, particularly for extensions. If we already have people on these visas and they get rid of an employment category, I don't know what that would mean exactly. So and again, a little bit of an unknown, but something to keep an eye on, to be a little concerned about. We also have obviously limits to other statuses that have been targeted. For instance, TPS, it looks like they're, going to start limiting the number of countries available, to which that's available. Venezuela, for instance, has already been targeted. There could be more coming. We don't really know what's going to happen with Ukraine. We do have some employees on Ukrainian TPS, so that could be a potential concern depending on how that shapes up. Refugee statuses, again, I know this isn't employment-based, but probably some companies do have people on these statuses. So just wonder, for continuity of employees and keeping people who are already employees on their statuses, something to be concerned about. We may need to start sponsoring people who are, otherwise not on sponsored visas, and maybe just increase, awareness of these things so that employees can come to us if they're on a status, because obviously we can't go through I-9 records and start reaching out to people. But I think increased awareness for people who might be on these statuses that, hey, we maybe need to look into employment sponsored options for you to keep you.
Yeah, you mentioned the America First trade policy. That sort of reminds me of the old Buy American hire American. And so I'm just wondering, back in the prior Trump administration, did you have to make any changes as to how you were filing petitions or how you were presenting petitions, or, what are you kind of anticipating this time around? And if it's going to be maybe a callback to that policy, just get your thoughts on that.
Yeah, so it is very similar to Buy American, Hire American. And I think that's the trend, again, that we can probably expect. But again, we don't really know for sure. They did already also rescind some prior executive orders that were aimed at helping to make visa processing more efficient, particularly through USCIS. And that was kind of what we saw last time. I mean, right, that we basically saw, again, strictest interpretation of the regulations, where specialty occupation was really under scrutiny. I mean, I remember seeing people who were here 10 years on an H-1B who now are told they don't qualify for H-1B status, things like that. So I think strict interpretation of the actual legal standards, potentially, just making things a little bit more difficult, increased filing fees possibly down the pipeline, longer processing times. They already extended the premium processing timelines last year, making it 15 calendar days as opposed to 15 business days as opposed to 15 calendar days. I think things like that, unfortunately, could start happening again, just in line with this America First. We want to basically make it difficult, or more difficult to hire foreign talent as opposed to U.S. talent.
Yeah, and I'm wondering if with every visa petition, it's going to be like, we need to kind of have like a mini perm recruitment just to show that there weren't U.S. workers every time you're, that we're able to take a job every time you're filing a visa petition for somebody. And then sort of the other interesting thing to note is that last year, under the Biden administration, we had seen a lot of changes being made to USCIS policy that were more friendly to STEM occupations and STEM applicants. And so it's just kind of interesting that to see what will happen with regard to those changes, because obviously with tech companies, you're hiring for a lot of STEM positions. I am curious to see what changes these policies will actually have on the adjudications themselves.
Yeah, and I will say, particularly with the O1, that was huge, having that STEM guidance in the policy manual that you could cite to. It made a difference in our cases. We've had a lot of success with O1s for STEM occupations over the last couple of years, which obviously before was a little bit more tricky. I think they were harder on those applications in the past. So I am also curious to see what happens with that, if they keep that guidance in there, if they're going to continue to kind of allow that to be basically a better, more secure option, because H-1B cap is clearly limited. L1 limited, because if you're hiring new talent or if someone hasn't been with your company for a year, there's not much you can do there other than rely on the lottery, which is, obviously not ideal. So having that O1 option available to people was really helpful. So I'm curious what's going to happen with that too.
Yeah, definitely. So, I mean, kind of along those lines, what do you anticipate seeing in terms of rescission of prior orders, or, kind of just backtracking on any policy changes that were made under the Biden administration? What do you expect? I mean, like we said, we do see that maybe those STEM specific policy changes may go away. And we did talk about the increased vetting. I'm seeing maybe more RFEs and more denials. What about you?
Yeah, and I guess from a preparation perspective, going back through old petitions from the prior administration might be helpful, just to kind of get a sense of, it was 4 years ago, but kind of remembering what to expect, the types of denials and RFEs we were getting. Level 1 wage RFEs, I could see coming back. That was a big issue back in the prior administration. I don't see any, changes that the Biden administration made that wouldn't be easily undone in that regard. To that point, there were a couple of things that the Biden administration did put into federal rule, like the new specialty occupation definition, which does allow for, a little bit of a broader range of degrees to be accepted. So that's something that I think would be helpful because there is actually a federal rule that you can cite to now. Same with the deference to prior approvals. I think that was a huge, issue. Like I said, people who had been in H-1B status are now being told that they're not qualified. Having it in a federal rule that you can only really go back and deny things for fraud, misrepresentation, things like that, and that we don't want to have people getting denied for something that they previously qualified for that really hasn't changed. So I think that is helpful that some of those things have been put in federal rule. Obviously can be undone, but it's a little bit more difficult. You can't just sign an executive order or issue agency guidance to say this is what we're doing now. But again, I think the bigger things are probably going to be the things that they can do with easy action, increasing filing fees, decreasing, productivity, making premium processing a little bit longer. And then, like level 1 wage. And then even last time I remember there was a rule that was in process that obviously Biden administration did not go forward with to actually change the H-1B lottery to make it wage-based. So these are the things I'm a little concerned about. And again, getting back to the STEM specific reasons this is important. A lot of people on STEM OPT are clearly, reliant on the H-1B lottery. They're not going to qualify for those O1s usually yet because they're just out of college. They've only been working for a couple of years. It'd be really difficult for them to, advance that far. So the H-1B is really, truly the only option for a lot of our recent grads. And if they start making it wage-based, that would obviously, be huge because unless they're at level 4 or level 3, they're just not going to get selected in the lottery. And that's a little unrealistic for a recent grad. So I think it would take a whole talent pool basically out of the picture, which is obviously a concern.
Yeah, and you raised STEM OPT. How concerned are you that the work authorization for the STEM OPT work authorization will go away?
Pretty concerned. Obviously, again, that's just one of our biggest, talent pools is recent grads, and a lot of them happen to be on OPT. It just limits their chances, right? They would only get one chance at the lottery as opposed to 3. We would probably end up having to pursue alternative options or just not hiring, people who are on OPT because we just know that it's limited in duration. And having those 3 years makes a big difference because I have a lot of people who get selected on their last year of STEM OPT. It obviously makes things easier for us. Also, if they've been around for a couple of years, it makes it easier and we can justify more making alternative solutions for them, like sending them abroad for a year and then bringing them back on an L1 if we really want to keep that talent. But if they're only around for 6 months to a year, it's difficult to assess, whether it's worth it, frankly, because it's very expensive, obviously, to get them a visa in another country, send them to, Canada or Europe or, India or wherever we decide to send them for a year and then bring them back. So it's something that having a couple of years to really get to know an employee from an employer's perspective makes a huge difference and makes a difference in what we're willing to do to sponsor them also.
Yeah. So maybe let's move on to how are you guys preparing for all of the changes that we just discussed?
Actually, I was just at our headquarters last week and going through some of the physical documents that we have because pre-COVID, we were keeping public access files and perm audit files physically and not storing them electronically. So that's one project on my to-do list for this next quarter is to maybe make another trip out there and get all of those files transitioned to electronic storage. I think that's important because I'm remote. I'm not on, the headquarters. And if something happens, if we're asked to give, files to the DOL, we only have 3 days to do it. So I want to be prepared and make sure that I at least can access everything quickly and have it ready. Another thing that, we need to do is make sure our HR teams and people who are at headquarters are on site. If the attorney or whoever's in charge of your audit files is not there, make sure that they know, number one, who to contact if somebody shows up. And then kind of just prepare them. I'm probably going to put together just a short document for each of our HR people at our different sites to just let them know what to do if somebody shows up. I think that's, important to just make sure the people who are going to be on the front lines receiving these requests and, being there when somebody shows up for a site visit or for a DOL audit or for an I-9 audit, just making sure that they know what to do, what to look for, how to check the warrant, how to make sure that it's valid, knowing exactly what they're looking for before they just start letting somebody on site, and then again, who to contact. So obviously in my company, that would be me. But I think in other companies who don't have in-house immigration counsel, it's important to make sure everybody has the contact to your outside counsel or whoever handles your immigration processes. And, again, somebody internally, maybe on your legal team or in HR who you trust to be the one to really interface and make sure that, you're managing everything properly.
Yeah, no, I think that's really good advice. I mean, I know that right now in the news, it's all about ICE raids, but I think that same advice can be given whether we're talking ICE or whether we're talking, the fraud group that inspects for H-1B and L-1 fraud, or we're talking, an I-9 audit. I think the advice that you just gave is the same regardless of what kind of immigration enforcement or, which body is actually doing the enforcement. I think that advice stands and is good for either. You mentioned reviewing your perm audit files and your public access files and making sure that those are in compliance. I do think it's important maybe for us to just quickly touch on I-9 compliance. You had said, for instance, with your H-1B public access files that you were keeping those in prior to the pandemic, that you were keeping them in hard copy. I know that technology companies embrace technology, and so a lot of them may be keeping their I-9s electronically as well. Mm-hmm. What are some of the concerns that you have, maybe not for your company specifically, but just generally about I-9 compliance and, the electronic files or even paper files? Like, what are some things that maybe people should be paying attention to?
Sure. So, again, generally, it's something we can expect potentially I-9 audits over the next 4 years. It doesn't hurt to go ahead and do an internal audit. That's, again, something that is on my to-do list for this year, because I think it's important to know. I mean, obviously, you have the chance to make corrections if you do an internal audit, which is helpful. But it also helps just to know where you are and know where you stand with everything. We actually use a vendor. So, it's a little bit different in my company as far as we don't manage the storage of, the I-9s and making sure that, they're completed properly, that all is outsourced to a vendor. But one important thing to note for other companies that may use vendors also is that you're still liable at the end of the day, right? So it is important to make sure that somebody in your company, whether it's HR, legal, or whoever, is managing that vendor, making sure that they're doing everything properly. And then also at the end of the day, too, you're responsible for re-verifications. So something to know is even if the vendor is managing everything, somebody needs to be in charge of logging in and getting alerts, because I know at least with our vendor, they will send alerts when somebody is potentially, when their documents are expiring, but they may not be with the company anymore. So the vendor isn't going to automatically go and reach out to do an I-9 re-verification. That's on the employer to go in and click that button and say, do that. So, got off on a little side tangent about vendors, but just thought that was important to note because I think a lot of companies do use them. It's it's helpful and it's something that is easy to want to do because it saves you resources internally. You don't have to hire as many people in HR to manage all of these I-9s. But again, there are some pitfalls, so just things to be aware of. But with respect to your overall question, again, I think making sure that you're doing internal audit before you get a real audit, and then keeping electronic files and keeping versus keeping physical files. Again, I think a lot of the COVID changes because the I-9 process was changing constantly during COVID. I think it doesn't hurt to go back through and just make sure that your files are being kept in compliance with what the regulations were. For example, they changed, I want to say every 6 months throughout the pandemic. It was something like that as far as what you actually had to do, how you were actually supposed to be verifying these documents remotely versus in person. So I would say go back and review the different guidances that were in place during those times and just make sure that you did keep everything in accordance with what was the guidance at the time. A big thing I think we talked about in preparation for this podcast was the fact that you actually had to video somebody seeing the documents and keep that video. I know we have the videos from when we did that. So just little things like that, again, were different, that everybody was adjusting to constantly. It doesn't hurt to go back through particularly that time period where it got very, confusing at times, and just reread the guidance, make sure that everything was done in accordance with what was required at the time.
Yeah, no, I think that that's a really good point, especially the live video.
Mm-hmm.
I think a lot of people think that, remote verification is now permissible. So email. Yeah, exactly.
Yeah.
So really, really important to go back and make sure that you actually are doing it correctly and you did it correctly at the time as well.
Mm-hmm.
So I think that's all really great advice. I think I know we covered a lot, but I think everything you gave really good advice that can be applicable to not only technology companies, but really any company. But particularly there were some things that we raised that I think are going to impact technology companies even more. So thank you so much for your time.
No problem. Thank you so much for having me. And I'm happy to come back anytime and talk about these issues as they unfold and as we get more information about what's actually going to be happening.
Thank you for joining us on We Get Work. Please tune in to our next program where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on Apple Podcasts, Libsyn, SoundCloud, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.